All right, these are We the People News. Okay, this next thing I want to show you is the key words to look for when he says this. Uh, Public safety with has to do with life and limbs, and this is what they always justify. Anything really, your property, um, public welfare, executive orders and all that. But it's life and limbs.
Well, if you actually read the laws on protecting the general public, it always says that somebody has to be put in jeopardy of life or limb. Well, there's your complaining party. Okay, you may not have actually injured them, but you have to put them. But see, they don't ever write you up for that. That would be reckless driving, which is a crime. You know, and that's where looking at due process. Okay, even on the commercial side, it still applies. Okay, you still because it still falls under civil and criminal. And when you understand those elements, then it's like either you have the evidence or you don't. Now, most 99% of the cases they dropped it because it's like, but see, they you'll never find evidence that they dropped it. They did docket it, and it goes away. Right.
Now we talked about hearing about wink, 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 sovereign citizens, show me the proof and all that. Well, they do that. The courts do this. They drop it. They kind of put it in a secret file. And the reason why it's in that secret file so it doesn't hit the public, but the judges actually keeps it. And then every year or every so often, they actually have a form of a judge meetings talking about the situations of cases that's been brought up and what are they going to do to counteract of these free people doing things. Okay, not saying all the sovereign citizen thing is a free thing. There's problems in everything. However, I am one of the people. What are they going to do about my paperwork? Right? They're going to brush it to the side until they have that conference, and then they're going to go in there and say, hey, what are we going to do about this situation that's been brought up? All right.
You don't hear from them.
You just quit hearing from them.
You quit hearing from them. Because, yeah, and I don't think I can figure, well, they don't want that information. Oh, they just don't want to deal with it. Well, if you...
All right. So we're going to get back into this right here.
Hey, Louie is...
A police officer as a parent or who isn't familiar and is being raised in this particular climate and seeing what they see on TV and seeing what they hear and everything.
What does that have to do with anything? Yo, I'm done watching her. This is so horrible. I can't deal with it no more. So what we're going to do here is I'm going to show y'all something. Watch this. So what I did is I pulled the transcript from the video itself and started to formulate some questions with ChatGPT. Within ChatGPT, I was really trying to focus on what can we pinpoint out in relation to the violations across the board in relation to this individual. Number one is the defense attorney's performance. The defense attorney failed to file motions and raise relevant constitutional issues. No mention of the fruit of the poisonous tree doctrine. The attorney did not file motions to suppress evidence based on constitutional violations, the Fourth Amendment regarding unlawful stop and search, and there was no motion to abate proceedings or challenge the jurisdiction of the court if defendant's travel was non-commercial and not subject to traffic statutes. She did not even invoke the rule of lenity whatsoever. The attorney failed to bring that up. The attorney conceded to probable cause. She conceded to it without challenging whether the officers lawfully initiated. She straight up conceded to it. Oh yes, they did have. We get it. They did have probable cause. Who told you? What? Excuse me. No effort was made to invoke Supreme Court rulings affirming the right to travel, and that private travel in not involving commerce may not constitutionally require driver's licenses or insurance. Then, the advocate effectively for bond reinstatement, the attorney relied on emotional appeals rather than addressing legal standards. She was blabbering. Now, on the judicial conduct and oath violations, bias and presumptions, the judge made biased statements about the defendant, such as, "You just refuse to accept authority." Quote, "When you get into a pissing match with someone with the power of arrest, you are nearly always going to lose." These statements suggest a presumption of guilt before trial, violating the defendant's presumption of innocence under the 5th and 14th Amendments. Now, improper legal assertions. The judge declared, "I don't care how you term it, driving or traveling, do not drive." Later in this video, he goes into, which I'm not even, should I get into it? Maybe so. Let's see if I can find it real quick. Hold on.
It is wrong. However, I'm employed upon the court to ask the court to take into a little bit of consideration. Number one, from his perspective, all defendants, can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now in the case. Well, you know about me. I'm a tight attorney. I run a tight ship. So, and by which way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll bite.
Yes, sir.
Okay.
Thank you, Judge.
I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. David? When you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
Right now.
You're not allowed to drive.
Hear what he said? Not right now. Now, right now. And homeboy says, "You're not allowed to drive." You're right, Your Honor. I am not allowed to drive. I don't use these roads, though, in a commercial capacity. Judge, Your Honor, can we distinguish the difference between drive and travel today? Here?
You have a bond condition, and you signed an affidavit with me today promising you're not going to drive.
Oh, he signed an agreement. Got him.
I don't care how you term it. Driving, traveling, however you're going to word it.
Uh-oh.
Now, even he got this incorrect a little bit, right? So he did sign an affidavit, agreed that he's not going to drive. Well, again, we're talking about terms in this video right now, right? So even with what he's talking about, him signing an affidavit that he's not going to drive, well, he's not driving still. He's still traveling. So that affidavit still does not apply with the contract he signed.
I don't care how you're going to word it. So apparently definitions don't matter. And the actions in which one takes on the road when case law all across the board from the Supreme Court on is very clear on what it applies to. You can go and look into the statutes. You can go and look into the policies, guidelines, training manuals within the Texas State Troopers, your police departments, and again, going into the municipal and county codes, which allow you to see that the roads are open as a matter of right for public vehicular travel. I don't know who these people think they're fooling anymore. Like, you're not fooling us. And if you continue to violate people's constitutional rights, not even that, I think we need to actually bring forth complaints just on these alone. These are enough to get this type of travesty and treason out of our country. Okay? It's that serious, y'all.
Whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road, unless you have approval from us. Do you want to?
Unless you have approval from us. Boy, I don't know. Excuse me, Your Honor. Excuse me, Your Honor. My client has not been found guilty whatsoever. I think what you are trying to impose are constitutional violations in which you have no authority to do. At this point, we're going to have to ask that you recuse yourself. Yo, I'm figuring out what I need to do to file something. Yo, this attorney is horrible. And this judge and this right here is so against the Constitution. And I'm about to show you how. And just, you know what? Let's do it right now. Let's do it right now. Okay, so now we get into the second aspect of me getting a little bit deeper in relation to what I'm asking ChatGPT under a major prompt or a big prompt that I have initially. And we're going into judicial and prosecution-related violations. So the first one is the judicial bias and prejudgment. The judge makes extrajudicial bias statements about the defendant's character, suggesting the defendant refused to accept authority, despite no adjudication of guilt. The judge shows impatience and reliance on incidental references, e.g., go on YouTube, pissing match, rather than maintaining a neutral judicial demeanor. By presuming a certain type of defendant, e.g., classic sovereign case, the judge adopts a prejudicial stance that undermines the presumption of innocence. 2. Judicial failure to recognize constitutional claims. The judge dismisses outright the defendant's contention about the right to travel without a license or insurance, neglecting to engage with constitutional arguments or related Supreme Court jurisprudence. The judge also appears to endorse the notion that compliance with the police command is absolute, and he did, without recognizing a citizen's right to be free from unreasonable searches or seizures. 3. Overbroad and potentially unconstitutional conditions on bond. The judge imposes conditions beyond the standard scope, e.g., prohibiting all driving, traveling in any motorized vehicle without consideration of due process or less restrictive measures. No analysis is provided of whether these bond conditions are proportional or constitutionally sound, particularly given that no conviction has occurred. Prosecutorial overreach and potential misconduct. Now, the prosecution's theory may extend beyond the statutory limitations if it attempts to enforce licensing, insurance, or regulatory statutes intended for commercial traffic against a non-commercial traveler.
We're going to pause right there. So even with my previous videos, we talked about the DWI meters and bonds, excessive bonds, and all that, right? Well, I mean, in this case as well, it's excessive, right? He's still being convicted before he's actually went to trial. They found probable cause, but he's still been convicted. They're still ordering him to do certain things outside of their court's scope and their four corners when he's allegedly supposed to be bonded. It says bond. It does not say anything else. We need to be clear on that. Them extending these things outside the four corners of the judicial branch is not okay. And we just get along to play along.
No limiting interpretation of the underlying statute is considered, nor is there acknowledgement of established legal precedents that differentiate between private travel and commercial operation. Failure by the prosecution to clarify or confirm statutory authority for demanding licenses or insurance under these circumstances can be seen as an overextension of prosecutorial authority. Okay? Now, while previous commentary has addressed the defense counsel's failure to raise constitutional issues, challenge probable cause, argue fruit of the poisonous tree, or invoke the rule of lenity, there are additional significant omissions that further illustrate inadequate counsel. Number 1, failure to demand recusal or raise judicial misconduct. The defense's counsel never formally objects to the judge's biased remarks or seeks the judge's recusal despite the clear appearance of partiality. The lack of objection, the overreach in bond conditions, the absence of a motion to suppress or challenge the initial stop, no formal challenge to statutory interpretation or scope, failure to counter negative narratives or preempt judicial bias, no effort to seek clarification or limiting instructions, inadequate use of defendant's lack of criminal history or community ties, and failure to build an appellate record. Okay? Now the conclusion of this here, now we're going to go even deeper because it happened in Texas. So we need those violations, those codes. What all violations occurred in this less than 8-minute section right here. Okay? So the constitutional violations for this section alone, okay? Literally, straight up all the way. Number 1 is the 6th Amendment. Ineffective assistance of counsel. Defense counsel failed to raise critical legal issues, file essential motions, and provide a meaningful adversarial challenge may violate the defendant's 6th Amendment right. Relevant case law, Strickland v. Washington, 1984. 2. 14th Amendment, due process and equal protection. The judge's biased statements and the appearance of prejudgment violated the defendant's right to a neutral and detached tribunal. Disregarding or dismissing constitutional arguments without a fair hearing does infringe on due process. The presumption of innocence. Judicial commentary that implies guilt or untrustworthiness before a finding of fact violates fundamental fairness under the Due Process Clause. Fourth Amendment violation as well. Unlawful stop and seizure. Now, if this initial traffic stop or subsequent demand for ID or insurance were not supported by proper legal authority and the line in which it has to go through first, any evidence obtained could be subject to exclusion under the Fourth Amendment. Of course, this is related to the doctrine of Matt versus Ohio and the fruit of the poisonous tree doctrine. Now, Texas constitutional and statutory violations that occurred just right here within this court setting, hearing, probable cause hearing. Number one is the Texas Constitution, Article 1. Section 9 protects against unreasonable searches and seizures analogous to the Fourth Amendment, providing a state-level basis to challenge the legitimacy of the stop. Section 10 guarantees the right of counsel and a fair trial. The failure of counsel to provide adequate representation violates the Constitution as well in Texas. Now, 2. Texas Code of Criminal Procedure, TTCP, Article 1.05, Rights of Accused, ensures the defendant's rights to due course of law and a fair and impartial trial. Judicial bias or refusal to consider constitutional arguments can violate these, or does violate these foundational rights. Article 1.051, right to representation by counsel. The defendant is entitled to effective counsel, not piss poor counsel, but effective. There was nothing effective about her ramblings of her personal opinions and her ties to the assistant chief of the police. Counsel's failure to raise constitutional objections, challenge probable cause, or file necessary motions constitute ineffective counsel. She literally agreed with the prosecution that it was okay for them to pull him out of the car and that he violated something by not giving his ID, not giving his information. Do you understand how wrong that is? That's what the judge did. She's like, oh, he was wrong. Go back and watch it. He is wrong. We're not saying.
Alrighty. This week People News. Bye.